You agree with what she just said? We're simply here on the interpretation of this particular statute, the 1991 version of this statute.
Yes, sir, taking into consideration the public policy arguments also.
Oh, yeah, sure.
Yes, sir. Not on the 1990 version.
No, you're right, the one that was in effect as of January 1st, 1990.
Yes, sir.
Yeah.
Actually, 1987 it was the statute, because I think we pretty much agreed that would be the statute that would have been in effect at the time of our case.
The 87 statute?
80, yes, because the offer, I think, was made in about 89. So it is the 87 version that this court is construing, as opposed to the fourth in Fortner construed the 90 version. But for all intents and purposes, they are essentially the same. The only thing that the 1990 statute did was the 1990 statute took the Rule 1.442 procedures that this court had adopted and changed them somewhat and said, okay, we are now putting some of the procedures into the 1990 version. And by the way, my name is Dan Cytryn, and I was the attorney for Marie Dvorak in the trial court below. The 5 issues that I want to speak to as to why this court should put a mandatory construction on this statute is, number one, the statutory construction is clear that if a party gets 25% more or less than the offer, they are entitled to attorney's fees.
Well, let me test that for a minute, Mr. Cytryn. Now, without this statute, there would not be an entitlement to attorney's fees. Isn't that right?
Yes, sir.
Okay.
That's correct.
And so why isn't it a proper construction here to merely say that where it says that if the plaintiff files a demand and gets 25%, that creates the fact that there is an amount more than 25%. That is merely the creation of the right to the attorney's fee. And then we look and see there in the paragraph D that the court can determine the reasonableness of an award, attorney's fees. And what I particularly want you to speak to is the fact that this shall be entitled language is different than 627428, which says shall a judge, which is mandatory language, 57105, which says shall award, and 768-495, which is punitive damages in malpractice cases, is shall award. 624155 is bad faith, insurers shall be liable. And in 627-6698, which is another bad faith provision, that's also shall award. And I would think that a fair interpretation of this is that this creates an entitlement rather than a requirement that there be an award.
Because the entitlement, as Judge Farmer explains in his scholarly opinion interpreting the wording of the statute in Schmidt versus Fortner, the entitlement is established here. As Judge Farmer explains, and using his words, he speaks better than I do, the word shall be entitled in subsection 1 quoted above cannot possibly have any other meaning other than to create a right to attorney's fee. So what he's saying is that number 1 gives you the right. Section 2A taketh away. Section 2A is the good faith requirement. You're number 1 entitled. Number 2, under 2A, your entitlement can be taken away if the offer was not made in good faith. And the last section, when determining the reasonableness of an award of attorney's fees, and I would like to point to a decision.
Well, I think where I'm having trouble is with the distinction between the creation of a right and the creation of a basis upon which a court could make a determination that attorneys' fees could be awarded. Can you speak specifically to that? Because I read these other statutes that the legislature mandated specifically that there was a mandated an award, like in 428, which says shall be awarded.
Here's what Section B does. What Section B does is it does what I'm calling a reverse multiplier. Section B then says, if look at these factors here, court, look at these 6 factors. You got the entitlement, there was no bad faith, now you're entitled to fees. Look at these 6 factors here, and let's see if we can apply a divider. And it's kind of a reverse row case, whereby what I'm proposing is that there be a divider of 1, 2, and 3. And depending upon how close these issues, the court can apply a divider so that if it was a close case, whatever the reasonable fee, whatever the lodestar comes out to be, if it was a close case, the court can use a divider of 2 so that the attorney's fees say the lodestar is $50,000. The court can then take into consideration the multiplier if it's in the case of a plaintiff on a contingency fee basis, and then apply these 6 factors to determine whether some of those attorney's fees should be taken away. Now, Justice Farmer said the now reasonableness of an award of attorney's fees, and I guess before I talk about Justice Farmer, Justice Grimes used the very words in an opinion in 1977 when he was writing a decision in the case of Universal Underwriters Insurance Company versus Georgia Enterprises. And in that decision, the issue solely was the entitlement to the amount of attorney's fees, how much attorney's fees. And in this paragraph here, Justice Grimes writes, the question of how much a reasonable fee is given is in a given case cannot be precisely answered. Then he goes on to say, at best, there is a range of reasonableness within which a trial court's determination should not be disturbed. Every case.
What statute was that under?
That was, I believe it was under 627.428, which is the attorney's fees.
An insurance
carrier. Every case that talks about the reasonableness of an attorney's fee in the state of Florida speaks to the issue of how much and not as to an entitlement. Now, as far as practicality and why this court should adopt the mandatory requirement, public policy, Your Honor mentioned, encourages settlement and discourages prolonging litigation. When a defendant or a plaintiff gets in an offer or judgment in this case, in a case, it's no longer a joke. I have seen cases that have settled because the defendant is afraid of this rule. If we are going to rely upon the discretion and the politics involved in making determinations as to entitlement under this statute, which is going to affect every civil case, we are going to burden both the circuit courts and the appellate courts with evidentiary hearings on entitlement.
But doesn't it really have a chilling effect for litigants to litigate their rights? An insurance company is sitting on a $25,000 policy, and otherwise they wouldn't have to, they wouldn't be subject to attorney's fees, and yet so they can litigate the issue of liability, or like in this case, could litigate the issue of liability, but they're confronted with a very substantial award of attorney's fees, then they're not going to litigate what they should be able to litigate, and that's the issue of liability.
The chilling effect was addressed in the Roe case by Justice Overton, and what Justice Overton said about the chilling effect and what this court should adopt is that the assessment of attorney's fees against an unsuccessful litigant imposes no more of a penalty than other costs of proceedings which are more commonly assessed. and we've always had costs. Now we're just raising up the ante. The legislature said, we're tired of all this litigation. We're tired of people thinking that they're going to the crap tables in Vegas. We want people to have to think about what they're doing. We want defense lawyers, when they get an offer of judgment in these cases, to think about it and not to write to their insurance carriers and say, I know this judge, he's probably not going to award attorney's fees against me even if I get hit, so don't worry about it. What this is doing is we're taking away the lottery. There's good and bad for both sides in this issue, and this is going to do what the legislature intended, is it is going to some small extent, encourage settlement and stop those persons from litigating frivolous cases that don't belong in the courtroom. What Justice Overton said, in certain causes of action, attorney's fees historically have been considered part of litigation costs, and Justice Overton mentioned the 70 statutes, and the award of these costs is intended not only to discourage meritless claims, but also to make the prevailing plaintiff or defendant whole. It can be argued, rather than deterring plaintiffs from litigating, the statute could actually encourage plaintiffs to proceed with well-founded malpractice claims that would otherwise be ignored because they are not economically feasible under the contingency fee system. And that's real true. Somebody comes into my office and says, I have a case, Mr. Cytryn, and so-and-so, and I say, well, you want to know something that's worth $50,000? I can't invest $50,000 in costs in this case. If I think this is a good liability case, I may just take that case now because I'm thinking, not only am I only going to make 40% of the $50,000, but I potentially can get the reasonable value of my services. I might get a $75,000 or $100,000 attorney's fee on that case. So I think that 10 years ago, Justice Overton realized that and put that in. He said the statute may encourage an initiating party to consider carefully the likelihood of success before bringing an action, and similarly encourage a defendant to evaluate the same factor in determining how to proceed once an action is filed. So therefore, I think that clearly the public policy of the state of Florida, which is the concern about the increased cost of litigation, that we will no longer have defense lawyers who could have settled this case 2 years before, now settling these cases on the courthouse steps because they want to build so that they can make money on the case and all of a sudden cave in at the very last moment. This statute will force them to seriously consider what the ramifications are, and if this is a $50,000 policy case, and the offer of judgment comes in for a reasonable amount of money, that they need to accept it.
Let me ask you this. On the matter, if I'm a trial judge evaluating the matter of attorney's fees under this statute, and under 7B, and I think that as far as generally speaking is concerned, that the services in this particular case should be worth, without anything else, $30,000. But there's factor that the then apparent merit or lack of merit in the claim. And as a trial judge, I think that this really was a justiciable issue. That it wasn't frivolous, that it wasn't a matter of undenied. Now, what effect does that have on what I consider to be, without considering these factors, a $30,000 fee case?
Now, my proposal, and of course, is the reverse multiplier, which I would call the divider, which are a factor, and I'm proposing a factor of 1 through 3. And if the court says, you want to know something? This was a real tough case, and therefore, based upon the 6 factors, substantial justification existed for not accepting the offer, then what the court will do is it will apply a factor of 3 and will divide the $30,000 by 3, and the award will only be $10,000. Because, and also the fact...
Would that also apply as to the closeness of the questions of law and fact, which would be interrelated to it? Item 3. In other words, it's a close question it's a close question both on the matter of fact and on the matter of law.
Well, the multiplier is the same thing. The multiplier says, okay, if the plaintiff had a clear-cut case in the beginning and it's a contingency case, he gets a multiplier. I think it's up to 1.5. If it's a medium case, then he can get, I think it's 2 to something of that nature. And if it's a real tough case, then under Quantstrom, he can get up to 2.5.
Then basically what you're saying in this instance, that what these factors do is in effect reduce the amount of what would be the normal attorney's fees by reason of their application.
They can reduce the amount, and the court does not have to have a hearing on entitlement. The court only has to have a hearing on the reasonableness of attorney's fees. And if under your scenario, the court says, well, $30,000 is the lodestar, that's the reasonable fee, but Mr. Jones, you should have settled this case. And this was clearly apparent from the outset. It wasn't a close case. And, you were making ridiculous offers of judgment for $1, and the plaintiff made a reasonable offer of judgment for $25,000 to settle this case. And it was clearly meritorious. And there was nothing about a test case here, and there was nothing about far-reaching importance. And you didn't cooperate under subsection 4, and you didn't furnish him information. So what I'm doing is I'm applying a factor of 1, and you're getting hit with the full $30,000 in attorney's fees. Your Honor, I didn't have a chance to address my issue on 45.061. Is there any way that I could get into that?
You still got time. Well, you got time.
You have additional time.
Okay. So Judge Farmer's opinion wraps it up. The Bridges case, which is the only case that in any way conflicts with this decision, looks to be almost dicta. Every other court, every other judge, including Judge Anstead, who sat on this case in the trial court below, construed this statute to mean a mandatory entitlement. Every other DCA has came out the exact same way, and what happened was the third DCA in dicta, in the second issue, they said, okay, the offer wasn't made in good faith, number 1. But then they said, and they intermingled the words good faith and attorney's fees, and reasonableness down here in their opinion, if you take a look at it. One other thing that Judge Farmer's opinion does not point out that I think is crucial to statutory interpretation. Shall be entitled to recover reasonable attorney's fees and court costs in 1. Now, however, if it's not in good faith, the court may disallow an award of attorney's costs and attorney's fees. Now, this is the clincher. B, when determining the reasonableness of an award of attorney's fees, where did costs go? Where did costs go? And the answer is that clearly these factors determine entitlement, and this factor determines only the amount of attorney's fees, because if the legislature intended that this court, or that the courts determine entitlement under this section, they would have put in the words award of attorney's fees and court costs. And so it occurred in a 1990 amendment that they also did not do it, but more importantly, this court adopted Rule 1.442 on the offer of judgment, and in 1.442, in subsection H1, it was not a mandatory sanction at that time. The rule said may impose sanctions. Well, when the legislature in 1990 adopted those rules from Rule 1.442, which resulted in this court in Timmons then saying, okay, we're abolishing 1.442 because we don't need it anymore, because now we've got, the legislature took in our rules in the 1990 amendment. The court changed, the legislature changed the wording, and it no longer said that it said the court shall determine the following. So it went from a may interpretation, which the rule had, to a mandatory interpretation. under the 1990 amendment. Shall means shall when it's a penalty. This is a penalty set forth by the legislature, and it should be mandatorily enforced. Do I have any time for 45?
Yeah, you got it until the red light comes on.
Yeah.
Okay, thank you.
How does, whether it's a test case or not, have anything to do with entitlement?
How does what, sir?
Whether it's a test case or not, what does that have to do with not entitlement, but the amount of fees?
If for
That's
example...
one of the factors, one of the 6 factors, and opposing counsel made that observation, and how do you respond to that?
If it's a, let's say it was a closed case, but it was a test case. I think the court recently had that thermogram case 3 years ago, where there was a substantial attorney's fee awarded. The fact that it's a test case would, for the plaintiff, I believe, enhance and increase the amount of the attorney's fee that the plaintiff was entitled to. It could work either way, actually.
Why? What relationship do they bear to one another? That's what I'm asking.
Well, in other words, if it could work either way. It could also work in the defense's favor. The defense could come in and say, and they tried to do it in this case below, they could come in and say, well, okay, we lost and you're entitled to fees, but it was a test case, so therefore we shouldn't have to pay that much of a fee. And the court can say, this was a case of first impression. Defendants had no idea that these issues were coming at them, and therefore the court should award a lesser fee under those divider factors that I've mentioned.
Okay. Thank you. Your time is up, and I think you've answered mine.
Will I have a chance on chapter 45 at all?
No, I think you've used it up now.
Okay.
But if it's in your brief, well, we consider the brief, and that'd be fun.